Welcome back, everyone, to Law and Legal Process. Today we're going to be continuing our discussion of contract law, but I'm going to be shifting the focus away from how contracts are formed and towards asking a different question. When should the law refuse to enforce a contract that appears to be perfectly valid? So, if you guys remember from the last lecture, I taught you all about just discussing how really contracts are coming into existence. We talked about a lot of the offer, acceptance, consideration, and genuine assent. I also introduced you guys to concepts like legal capacity, duress, undue influence, fraud, and statute of frauds, also the UCC. But today, I really wanted to look at more about how these principles are tested in real litigation. So instead of just repeating circular legal definitions, actually looking at three cases and how they more so represent a different reason of why a contract or agreement that looks like a contract might not ultimately be enforced. And so our first case is asking whether or not a minor should be able to undo a contract they legally entered into. Our second case asks whether someone who technically agreed to resign from their job actually exercised free choice. And our third case asks where the court draws the line between aggressive salesmanship and outright fraud. And by the end of today's lecture, I just don't want you guys to remember simple legal definitions. It's more so understanding the broader idea of how contract laws just value freedom of the contract itself. And this freedom only exists when the contract is entered into voluntarily, honestly, and by someone who has the legal capacity and is legally capable of making these decisions. And that's the central theme that connects all three of today's cases. So I want to begin today with a simple question. Suppose you were to sign a contract, and then a week later you end up regretting your decision. So should the law allow you to back out of your contract? Well, for most of us, the instinctive answer is probably no. If contracts could just be canceled by someone simply changing their mind, then contracts wouldn't really matter too much now, would they? I mean, businesses wouldn't be able to rely on agreements, consumers couldn't rely on promises made by businesses, and then, of course, the markets would just become unpredictable as a result. So that's one of the reasons why contracts are so important. They allow people to plan for the future because everyone assumes that agreements are generally going to be enforced. But if we complicate the situation slightly here, let's just say that the person signing the contract was, say, 16 years old. Well, what if they had been awake for maybe 40 to 50 hours and they were under intense emotional pressure when they signed the contract? What if the agreement was induced by months of intentional lies? Well, now the answer to the question I proposed before becomes much less obvious. So this is the tension that courts constantly face when having to decide whether or not contracts should be upheld. So, one hand of the argument is that they want to preserve, obviously, the reliability of contracts. But on the other end of the spectrum, they really don't want people taking unfair advantage of children, vulnerable individuals, or victims of fraud. So today's three cases are illustrating how courts attempt to balance these competing values. And so as we move through each case, just keep asking yourself one question here. Should this contract or agreement really be enforced? And you'll probably find that answer changes depending on the facts. And this leads us into our first case of Dodson v. Shrader that was decided by the Tennessee Supreme Court in 1992. So at a first glance, this looks like a simple dispute involving just the purchase of a used truck. But as you'll soon discover, it actually becomes one of the leading cases on contracts entered into by minors. So it really asks a deceptively simple question here, and that being, if the law is designed to protect minors, then how far should that protection extend? And most of us have heard things about minors just being able to avoid contracts, and in fact, many students actually come into contract law believing that any contract signed by a minor is automatically unenforceable because of their age. And that's just not quite true. The real reason is whether or not the law should always restore the minor to the exact position that they were in before the contract they signed, even if doing so would, be deeply unfair to the other party. And as we go through the facts in the case of Dodson v. Shrader, I want you to put yourself in the position of the judge. And, don't worry about the legal rule yet. Instead, just ask yourself what outcome seems to be fair as you analyze the case facts. So here's what happened. Joseph Dodson was 16 years old when he purchased a used pickup truck from the Shraders. Now, notice something important right away. There's no evidence that the dealership committed fraud here. So the seller didn't lie about the vehicle, the seller didn't pressure Dodson into buying it, the seller didn't exploit Dodson. So in other words here, there's just an ordinary commercial transaction to the eye. So Dodson inspected the truck, he negotiated the purchase, and he voluntarily paid about $5,000, $4,900, etc. So at this point, the transaction appears to be completely routine and fine. And if the story ended here, we probably wouldn't have a lawsuit, obviously. But unfortunately for everyone involved, it did not. Everything went wrong here, and shortly after purchasing the truck, mechanical problems began to arise. So Dodson took the vehicle to a mechanic, and the mechanic warned him that the engine needed significant repairs and recommended replacing it immediately. So think about this for a moment. Dodson did have a choice here. He could have stopped driving the truck and repaired the engine. Instead, he continued using it. Now, eventually, exactly what the mechanic predicted happened. The engine failed completely. And as if that wasn't bad enough, the truck was later involved in another accident that caused additional damage to the truck. So by the time the dispute reached the court, the truck had already just completely depreciated in value dramatically from its origin. The facts look very different than they did on the day of the sale when Dodson bought the truck from the Shraders. So the seller no longer had the truck in its original condition. The buyer no longer had a functioning vehicle, and yet the buyer still wants all of his money back. And this is where the real legal problem begins. So the legal issue before the court was, should a minor receive a full refund after returning property that has substantially declined in value? Now, on one side, we have a 16-year-old, and for centuries, contract law has recognized that minors deserve special protection because they often lack maturity and the experience to appreciate the consequences of major financial decisions. And that policy is still very important, but if we look at the other side, the seller was acting honestly. There was no fraud, there was no deception, there was no coercion here, and if the courts order a complete refund, then the seller gets back a truck that's only worth a fraction of when it was sold to Dodson at the beginning, right? And you have to wonder, is that fair? If we always protect minors, no matter what happens to the property, then businesses would bear all of the risks. But if we never allow minors to rescind contracts, then the traditional protections that we have in place for children would become meaningless. So you have to really decide where to draw the line in this case, and that's exactly what the Tennessee Supreme Court did. So the Tennessee Supreme Court attempted to strike more of a middle ground here, and the court didn't abandon the traditional rule of protecting minors. A minor still has the ability to rescind most contracts. However, the court recognized that just blindly applying the rule could sometimes produce unjust results, and instead they adopted what's called the depreciation rule. Now, under this approach, a minor who rescinds a contract may still have to account for depreciation or damage to the property when the seller acted honestly and fairly. And just think about why the court reached this decision. So the purpose here is protecting minors to shield them from exploitation and not to give them just a free pass to use the property, then substantially reduce its value and then obviously shift the entire financial loss onto an innocent merchant or business. So the court actually was just trying to enforce a rule that is balancing the interest of both parties here. And this balance between protecting vulnerable individuals and just maintaining fairness in commerce is really what makes Dodson v. Shrader such an important contracts case. So what should you take away from this case? So first, remember one of the most common exam mistakes? Students often say that contracts involving minors are void, and that's just not correct. They're generally voidable at the option of the minor. So second, Dodson illustrates that more modern courts are sometimes willing to move away from rigid common law rules when these rules create inequitable results. And finally, I think the broader lesson here is that contract law is just rarely about choosing one value over another. It's always about balancing competing values. And so the court here is trying to protect minors from making just poor bargains while also recognizing the honest businesses shouldn't always have to just bear the brunt of the full cost when property is damaged after its sale and depreciated as a result. And as we move on to the next case here, you're going to notice a similar pattern. The court isn't asking whether or not a contract exists, it's asking whether or not the agreement was truly voluntary. And that brings us to one of the more influential undue influences cases ever decided, Odorizzi v. Bloomfield School District. So our second case asks a very different question. So no one in this case is disputing that Mr. Odorizzi had signed his resignation letter. The real question here is whether or not the signature represented a genuinely voluntary decision on his part. So contract law recognizes that not all pressure is unlawful, and employers can negotiate. Salespeople will persuade you, and attorneys will always advocate. But there does come a point when pressure becomes just so overwhelming that the law no longer views the resulting agreement as a truly voluntary decision. And today's case helps us identify exactly where this line is drawn. So just imagine the sequence of events. Mr. Odorizzi had just experienced one of the more stressful days of his life. He had been arrested, publicly embarrassed, deprived of sleep, and emotionally exhausted. and this was regarding his sexuality. Shortly after his release, before he had any meaningful opportunity to recover or seek legal advice, they had a bunch of school administrators from his job, because he was a school teacher, so a bunch of the administrators of his workplace came to his home. And rather than encouraging him to just rest or consult any counsel, they urged him to resign from his position immediately. Now, ask yourself this: if you were in his position, would you freely be making any, rational decisions? I mean, this man had been awake for nearly 40 hours under interrogation at the time. So Odorizzi actually ended up signing the forms, but this really brings us to the legal question in this case regarding whether or not the resignation was a voluntary choice, or was it the product of undue influence? And that's why it's an especially interesting case, because the court didn't really just begin by assuming undue influence. It was really asking whether or not another legal doctrine had better explained what happened in Odorizzi's case. So the careful approach is really the reason that this opinion is widely cited today. So I want to clear this up too regarding this case, because many students often confuse duress and undue influence. So duress usually involves threats or coercion that leave the victim with no reasonable alternative. And here, no one is threatening Odorizzi with violence or making him an unlawful demand. The administrators just came to his house and applied just a tremendous amount of pressure, but it wasn't the kind of pressure that was traditionally required to meet the requirements for duress. So the court kept on looking here. Now, why undue influence? Well, the court was focusing on Mr. Odorizzi's emotional vulnerability. Like I said, he was held up for 40 plus hours of him staying awake, so he was mentally exhausted. The administrator sent multiple people, so there were just multiple people persuading him to resign, and the immediate decision demanded just no opportunity for him to seek any sort of independent advice from counsel. So the court really emphasized here that Odorizzi had been awake for a very long time. He was emotionally vulnerable. He was facing several different administrators urging him to make an immediate decision. And when you take all of these facts together, it suggests something more than just ordinary persuasion. And the law protects voluntary agreements, but not agreements that are extracted from someone whose judgment had just been effectively overpowered in that moment. So the rule to remember with this case is that undue influence occurs when excessive pressure overcomes the free will of a vulnerable person. And Odorizzi has become one of the leading cases in defining what undue influence is. So the court didn't just create a bright line rule here. Instead, it identified a series of circumstances that, when you take this together, it demonstrates just an overuse of persuasion. And whenever you see a contract question involving emotional vulnerability, isolation, multiple persuaders, or demands of an immediate decision, Odorizzi should definitely come to mind. So just keep this case in mind for future. Okay, so we've reached our final case of Syester versus Banta, and this definitely has some of the more unusual facts in the entire contracts unit. So unlike some of the previous cases, no one claims that the plaintiff here, Syester, lacked any legal capacity. No one claims that she was physically threatened. Instead, the allegation is a little bit more complicated. It's that she was essentially manipulated over a long period through repeated false representations. And the case is asking, where does the law draw the line between enthusiastic sales tactics and just actionable fraud, right? So when we look at the case facts here, just to, spin the yarn and give you the story, Syester was this 60-year-old widow who didn't really have any friends, not a lot of family, and she got some dance lessons and enrolled at this Arthur Murray dance studio. And so the instructors, they hired a lot of people who, as far as visual aesthetics are concerned, were better looking, and they had a lot of good moves. They could cut a rug, essentially. And so the instructors went out of their way to kind of just repeatedly praise her and her progress, and suggested that she just possessed exceptional talent, okay? She was like dancing with the stars, she was look maxing, and whatever else you want to say. They continued this praise for over months and were consistently just, pairing her with recommendations that she should purchase additional lessons. And eventually, she actually spent just an extraordinary amount of money, 3 lifetimes worth of dance lessons. And she believed that she was a genuinely, potentially just unbelievable, true anomaly, best dancer in the world, okay? So the overall court's concern here was whether or not these were merely opinions or whether or not they were intentionally misrepresenting her and designed to induce additional purchases from their dance studio. And of course, the distinction here is pretty critical. The law generally does permit puffery statements like, oh, this is the best product you'll ever buy, this is the best beer you'll ever buy, or, again, these are more opinions. Fraud, however, involves a material misrepresentation of the facts that are intended to induce reliance. So the court had to decide whether or not the dance studio's conduct was crossing that line. So the overall holding here, evidence of continuing misrepresentations could support recession of the agreements. So the Iowa Supreme Court did conclude that the plaintiff Syester had presented sufficient evidence of fraud to proceed. Again, think about the statements too here. I mean, the significance of the case here isn't just simply that someone is exaggerating Syester's dance abilities. I mean, she's a 60-year-old woman, and they're giving her like first place, second place, third place dance awards, and essentially under the pretense that she's buying these lifetime contracts from them. And it's a deception that's formed on this ongoing pattern designed to secure increasingly expensive contracts with their studio. And the only reason she was doing it was because she liked one particular dance instructor, and she ended up suing them twice because of this, due to this misrepresentation, because the truth is, her dancing never improved. That's the sad part. So the court recognized overall that the repeated misrepresentations from this studio can fundamentally undermine genuine consent. And so when we compare these three cases, just notice how each case protects a different aspect of contractual fairness. Dodson protects individuals whose legal capacity is limited. Odorizzi protects individuals whose free will has been overcome. Syester protects individuals whose consent has been induced by deception. So some final takeaways here. As I conclude today's lecture, just remember the contract law is built on two competing ideals. On one hand, society depends on reliable enforceable agreements, and on the other hand, the law recognizes that not every signature reflects just a fair bargain. Sometimes the person signing the contract lacks legal capacity, sometimes overwhelming pressure replaces independent judgment of a person, and sometimes deception destroys genuine assent. And so the common thread, if we were to run it through all of the cases, is that the courts, they're not eager to set contracts aside, but they will do so when enforcing the agreement would undermine the very principles that make contract law legitimate in the first place. So as you prepare for your upcoming quizzes and exams, just don't simply memorize the holdings here. Instead, ask yourself the question we've returned to throughout today's lecture of, why did the court believe enforcement would or would not be fair? And if you can answer those questions, then you'll not only remember these three cases, but I think you'll also be able to understand the broader philosophy of contract law. But with this said, I thank you all for your time, and I conclude today's lecture.